The chair recognizes the House Leader for the third party.
Thank you, Madam Chair. I rise to move the amendment standing in my name on the order paper to add a new clause 28.1 to the bill. Chair, this motion requires, or this clause requires all regulations that are made, amended, or repealed under this Act to be, as soon as practicable, be published on a publicly accessible website. It must include a summary of the regulation made or amendment, a rationale for the enactment, amendment, or repeal of the regulation, and any other prescribed information. The clause ensures transparency and accountability of government decision-making as the government navigates these changes, and I encourage all members to support this amendment. It's on.
The debate is now on the new clause 28.1, moved by the third party House Leader. Member for Kelowna Mission.
Thank you. Appreciate the amendment brought forward by the member. Certainly I see a lot in here to like. We on this side of the House are certainly favorable to this kind of transparency, this kind of disclosure, and I certainly intend to support the amendment.
Attorney General.
Thank you. So we'll be supporting, or I'll be supporting this amendment. I just want to thank the member for bringing it forward, and I've really appreciated the discussions we've had to work together and along with many members of the public to make sure that this bill is a strong one and that it helps us in the face of the threats that we're having. So I appreciate the work.
Thank you.
Thank you, Madam Chair. I will also be supporting this amendment. This is a topic that we have discussed multiple times in previous parts of the bill, if members here may recall. So this is something that should be looked at because that transparency for the public. In the last part, we talked about some of the need of public reporting and making sure that that's possible, but there was also that reporting to the making sure that the public has knowledge of what's actually happening, that the business community can see what's happening, and I think that's the reason I'm supporting this amendment, and I'll thank the House Leader for the third party for bringing this forward, and I'm pleased to support it today.
I want to thank the third-party House Leader for bringing this proposed clause amendment as 28.1. Throughout this debate, we have been talking about accountability. We have been talking about transparency. We have been talking about getting information out to the public about this bill. And the publishing requirements under this proposed amendment actually address some concerns that we have been highlighting. So I echo the remarks of my colleagues from members from Prince George, Mackenzie, as well as Kelowna Mission. I will also be supporting this proposed amendment.
Shall the amendment to add a new clause 28.1 pass? Aye. So ordered. And House Leader for the third party.
Thank you, Madam Chair. I rise to move the amendment standing in my name on the order paper to add a new clause 28.2 to the bill. Honourable Chair, this amendment, should it pass, will task a select standing committee of the Legislative Assembly to be referred all regulations made under this Act. The committee will have 30 days after the date of a regulation is filed to begin a review of the regulation. The select standing committee will be enabled to file interim reports on the regulatory reviews or the reviews of regulations and present a final report on or before September 1st, 2027. Honourable Chair, this amendment allows the committee to have the ability to receive and review regulations as soon as practicable, and is a practical way to ensure legislative oversight. I hope all members will support this amendment. Thank you.
Forget who I was.
Attorney General.
There we go. Yeah, that's me. Thanks, Chair. Just wanted to also show my support for this amendment, and again, appreciate the work of the member and all of our work to get this bill across the line.
Member for Prince George Mackenzie.
Thank you, Madam Chair, and this is an interesting amendment that's been brought forward by the House Leader from the third party. I actually, in fact, was considering an amendment to this clause, myself. And, you know, we have been, as the opposition, have been tabling amendments all throughout this process so far. And so I had been considering an amendment that would direct this to the Select Standing Committee on Finance and Government Services. But in considering this, I actually prefer the amendment as proposed that we're discussing right now, because I think this requires a special Select Standing Committee, and I think that would be very useful to private members, especially those private members who have taken part in this debate thus far. I think it is important that you know, I myself am not on the Select Standing Committee of Finance and Government Services, but I think some of those I'd be happy to sit next to the member from Saanich North and the Islands as part of that committee if appointed to do so. But I think it goes to part of why this is needed. We've talked a lot about the need for legislative oversight, and that's something that throughout the course of this entire bill, as we're now, you know, the last part finally of this Bill 7, I certainly am very glad that we were able to vote down Part 4 that the public had an outcry for. I was pleased to be in the room to witness that. But we still do need oversight and transparency. We're not going to get that as we've canvassed it in this room already. We as MLAs are not going to be, on the opposition side, able to scrutinize some of these regulations as they're brought forward. They are going to be ordered by Cabinet. In the last part that we were talking about, it was, of course, on the ability for the government to have pretty wide-ranging power in establishing, varying, or revoking of poll systems. And that's something that the opposition or us as private member MLAs won't have an opportunity to take part in some of those discussions. Even though you know, that can actually be considered taxation-like authority. So to the executive, when Section 53 of the Constitution Act of 1867 reserves all money bills to the legislature, and that could be something that can be considered a money bill. So we are concerned about that. We're concerned about the fact that the opposition, whether it's in internal interprovincial trade, whether it's in procurement directives, or whether that's in the tolls, fees, and charges, that the opposition still will not be able to take part in some of the discussions on how those are going to be implemented. There still is broad sweeping powers from this bill. So MLAs need to be able to review those after the fact, and that's why I think this amendment will actually give MLAs the opportunity in a Select Standing Committee to make sure that we have knowledge of what's happening, that we can review it, and that the public, we can bring transparency to it moving forward. So in that case, I will be supporting this amendment, and thank you for the time, Madam Chair.
Kelowna Mission.
Thank you, Madam Chair. To echo what's been said by my colleagues, certainly we remain concerned about some of the aspects of the bill. We remain concerned about the lack of oversight, and that is precisely why we're pleased to see this amendment brought forward, and the Attorney General signaling that the government will be supporting it. I think it's certainly fair to say that We appreciate not only the intent of the amendment, but also the structure and thought that has gone into it by the member. So certainly I will also be supporting the amendment.
Thank you, Madam Chair. I just want to clarify one point so there's no confusion on this. This clause establishes that it'll be a select standing committee that does the work of reviewing regulations, so this won't be a special party committee. And I think the whichever select standing committee is designated for the purposes of this clause, we will find a stampede of MLAs who are qualified to be on that committee, lobbying to be on that committee to be able to participate in this work.
Attorney General.
I just wanted to maybe take a moment to say that there's been a real level of solidarity in this room and in the last two clauses that I haven't seen in the debate yet. And I think it's hopefully a sign that we all understand the threat and the what we're facing, and that we need to work together as British Columbians to face that, and that it leads to support of the work through this bill.